May it please the court. We turn to irrationality. If one had read nothing more than paragraph 4 of the grounds of appeal, you might have thought that you were going to be hearing an argument from Elliott based on a failure to take into account relevant considerations or taking into account irrelevant considerations. But the substance of what you have heard is a direct challenge to the rationality, the substantive rationality of the decision to dismiss option 1B. And the appellants have to face up to the task that they have set themselves. Second preliminary point, we again will come back to this at the end of this section, but our submission is that the contractual context has no traction in this entire line of argument. I won't go back to it, but the Divisional Court's judgment, paragraphs 171 to 179, sets out the approach that they take. And it is entirely true, by referring back to section G above, they do refer to paragraphs which mention the contractual context, because the contractual context is the fourth of the four contextual considerations in section G. So there is a textual reference to contractual context. But when one actually looks at the grounds upon which the challenge is being brought by Elliott, our submission will be that the contractual context has no relevance to the basis upon which the challenge is made to the decision to dismiss option 1B.
Paragraph 173.
Yes.
Judgment does specifically state the claimants consented to subject themselves by contracting on terms provided for in the LME rules. I think.
Yeah.
That appears to be suggesting that there's some principle of public law that if you consent to a certain decision-making process, that somehow that is relevant.
I agree, that carries that implication. The fact remains that we aren't here conducting a sort of a textual analysis of the Court of Appeals, of the Divisional Court's judgment. You are simply assessing the viability of the grounds of the challenge. And so if the grounds of the challenge do not depend upon demonstrating that the Divisional Court granted the LME or LME Clear an inappropriately wide margin because of the contractual context, unless that is part of the case they prove, then the words in the Divisional Court's judgment that happen to refer to contractual context have no relevance in this appeal. And that is the position we would submit. So can I work my way through briefly why we say that is so? The skeleton, again, I won't ask you to go to it, but just so you know where the hook on which I hang this line goes, exists. So it's paragraph 44 of Malone Friend's skeleton. She says that the thrust of this part of the argument is directed towards the respondent's approach to risk, the risk of default, and systemic risk to the market. That is what we are looking at. So since that's the focus of the challenge, can we just work our way through a number of contextual points first? The first is urgency. We've touched on this very briefly. The fact is that the LME's view was that the suspension of the market did not relieve the urgency of deciding one incidental point about deferring delivery, which doesn't concern you, but secondly, margining, and thirdly, the interrelated question of the status of the Tuesday trades. That's Chamberlain 1, paragraph 7, and paragraph 200. Now, the Divisional Court, rightly, in our submission, accepted that there were three reasons three reasons for the urgency in reaching decisions as to margining and the status of the Tuesday trades, and that's paragraphs 127 to 132 of the Divisional Court's judgment. And the three reasons why the urgency remained were, first of all, that things being as they were before the cancellation decision was taken, first of all, LME Clear was potentially under-collateralized to the tune of 19.75 billion. Secondly, many members trade in different metals, and the fact that the nickel market had been suspended didn't prevent them from continuing to trade, didn't prevent those members continuing to trade in the other metals. And so to the extent that members who were at risk of default continued trading on those other metals, that would potentially increase their exposure, which would have aggravated the impact of any defaults. Now, my learned friend suggested orally, and this is the first we'd heard this line of argument, that somehow market participants could adjust their decisions in relation to other metals. Who knows? That's not a submission made on basis of any evidence at all. It's pure lawyer's speculation. And it is entirely possible, plausible, likely, that people trading in tin, copper, or other aluminium would need to trade for their own commercial reasons, either because of supply requirements or because of hedging requirements. It is late and speculative to suggest that that risk of trading in other metals was not a real one or would somehow be mitigated by the market itself. And the third reason why the Divisional Court accepted that urgency remained despite the suspension is that all members, including those who were not at risk of default, needed to know whether the Tuesday trades would stand so that they could take their own commercial decisions on hedging and so on. Now, all of that is expert market evaluation by the LME Clear. None of it has got anything to do with a contractual basis of a relationship with members. And Elliott doesn't really even challenge urgency as such, as far as we can tell from paragraph 81 of their skeleton. So the situation remains urgent. That's the first point. Second point, the decisions on margining.
I'm so sorry, Mr. Quay. Can I just interrupt you for a second? This feature of the case, to which the Divisional Court seems to attach some significance, indeed it seems to have featured in their reasoning as to why they granted permission to appeal, rather than leaving it to this court. This feature of the contractual context, is that a submission that you made, or was that something they...
No, I have to admit, I don't remember making it at all. If we did, we made it... No.
No, thank you.
We certainly played it hard and long on expertise, specialist, margin, for all those reasons.
If I may say so, I'm not surprised to learn that. One has heard those sorts of submissions frequently. But the one about contractual, somehow consent is relevant to public law. I've never heard that before.
I don't believe it came out of our mouths or our pens.
Thank you.
Urgency. Second point, the decision-making on margining and on the status of the Tuesday trades were related, and essentially, because the reasons are, the two reasons for that, is that both decisions, both issues, impacted, obviously, on the amount of margin that would be called, and both of them engaged questions, as it's put, I think, in the evidence, as to the representativeness of the Tuesday trades as true market prices in the sense that we have described. And the Divisional Court accepted that the two decisions were inextricably interlinked. That's paragraph 81. And again, that has nothing to do with the contractual context, and there is, with respect, nothing that the appellants can or have said to suggest that those two issues were not properly interlinked. And at the very lowest, all I need to say in this court is that there is no basis on which they can try to persuade this court to overturn the divisional court's acceptance of LME Clear's view that the two issues were linked. Third contextual point, before we get to the substance of the decision, the third contextual point, my learned friend Skeleton tried to imply, and I think my learned friend in oral submissions actually said, that the decision was hastily taken. It was not. There were 24 people on the call at 9 o'clock. The participants came to the call already knowing what had been happening in the preceding hours of trading. The call lasted nearly an hour. Other alternatives were discussed, and the cancellation decision was not actioned for 2 hours after the call, during which time Mr. Chamberlain continued thinking about it. In particular, he reviewed the second default risk spreadsheet, and the intention to adopt the cancellation decision was communicated to the special committee before it was actioned, even though the special committee was not the decision maker. It was not a hasty decision or taken on an uninformed or ill-considered basis. Fourth contractual point we've already touched on.
The fourth contractual point. Clearly that's hanging over you, this issue.
The fourth contextual point we've already mentioned is that option 1A was rightly rejected, and learned friend now seems to accept that. One then, with those contextual points, one comes to the margining decisions that were taken. So far as the substance of the margining decisions, LME Clear took the view that it would have been unacceptable from a risk management and regulatory compliance perspective, indeed that it would have been wholly irresponsible to have margined the Tuesday trades by reference to the Monday closing price. That is Farnham 1, paragraph 139, supplementary core bundle, tab 4, page 189, Farnham 2, paragraph 14, supplementary core bundle, tab 7, page 237. The Divisional Court accepted that the LME Clear's judgment on that was rational. Indeed, it held that the margin decision was right. And that is Divisional Court Judgment, paragraph 203, Core Bundle 1, tab 7, page 148. Our submission, very simply, is that nothing has been put before you that should lead you to reach a different conclusion. Without labouring the point, the margin decision is clearly taken by a specialist decision maker in relation to a highly technical issue, in respect of which the issues are matters of judgment. We've seen the regulatory obligations to maintain sound risk management and so on. These are issues that require judgmental views to be taken by a specialist, and the decision here is clearly taken by the appropriate designated specialist decision maker in the wholly exceptional circumstances that we have explored, under time pressure, but with the benefit of full debate. And the Divisional Court's acceptance of the LME Clear decision on that, again, has nothing to do with the contractual context. It simply defers to, entirely appropriately, the expertise of the LME Clear. So Elliott's answer to that is to say, well, the Monday closing price must have represented an acceptable proxy price by reference to which the Tuesday trades could have been margined, and clearing procedure A6.10 was the available regulatory tool for giving effect to that option. Essentially, this is just a rehash of the argument that was run and failed in the court below. So I don't want to spend too long on it, because nothing new has been said, no new evidence is available, obviously, and this is simply a situation where Elliott is asking this court to retry the issue as to whether or not the expert decision maker took a rational view about the appropriate approach to margining. The only difference between now and the hearing in the court below is that in the court below, Elliott, along with Jane Street, relied on the evidence of Mr. Dodsworth. That evidence was discounted for good reason by the divisional court, and Elliott cannot rely on that. So with the greatest respect, it is in a worse position than it was in the court below, because it cannot rely on competing expert evidence. That has been discounted by the court below for good reason. As it happens, Mr. Dodsworth was expressing views in relation to margining when he never worked for LME Clear. He didn't have a role or any responsibility in relation to margining, but he saw fit to express a view that LME Clear could, compliant with its regulatory obligations, have margined the Tuesday trades by reference to the Monday closing price. The divisional court dismissed a reliance on his evidence. Malone and Friend quite rightly can't revive reliance on it. So the position in this court is that there is no competing evidence to challenge LME Clear's view, and there is a divisional court decision taken on entirely coherent and well-reasoned grounds for accepting that LME Clear's view that it would have been wholly irresponsible to margin the market on by reference to the Tuesday trades by reference to the Monday closing price. So I don't, as I say, wish to spend too long on this. The evidence, the best, clearest evidence about this is Farnham 2, paragraphs 15 to 17, which is in the supplemental core bundle, tab 7, page 237. And essentially, the narrative he gives there is that, yes, the decision on the Monday was that the market remained orderly. Pro tem, a decision was taken on the Tuesday to leave the Monday closing price until a decision was taken to leave the Monday closing price as the reference price for margining until a decision was taken on the status of the Tuesday trades. The market having then been suspended, the nickel market having been suspended, there was thereafter no new trading data by reference to which any different margining decision could be taken in relation to nickel prices. So there is no confidence, there's no decision that the Monday closing price remains, in a sense, right, but there's no better alternative out there for margining the market during its period of suspension. So we are in the very simple position that Mr. Farnham has expressed a very clear and cogent view as to the inappropriateness of margining, as I say, the Tuesday trades by reference to the Monday closing price. The divisional court accepts that that is an entirely appropriate approach, and the divisional court dismissed Elliott's challenge, the claimant's challenge in paragraphs 197 to 204 of the judgment below, and again, it did so on the basis of the LME Clear expertise and nothing to do with the contractual relationship between the parties. So in our submission, the position in this court is extremely clear, far clearer than it was in the court below, that the margining decision, it was entirely reasonable and there is no basis for this court to overturn it. That being the position as a matter of substance, it does not advance my learned friend's case at all to point to clearing procedure A610, which is the power to adjust the reference price for margining. That would have been potentially an available regulatory mechanism for doing, I say potentially, which I'll explain in a moment, but it could potentially have been a regulatory a tool for doing what Elliott is suggesting, if doing what they suggest was the appropriate thing to do. But for the reasons of substance we've looked at, it wasn't. So simply pointing at the mechanism that, a mechanism that could have been employed, doesn't advance their argument at all. As it happens, we submit that clearing procedure A610 could not have been used properly in the way that Elliott has suggested. Because if one looks at A610, it may be convenient to go to that. It's in the supplementary core bundle, tab 13, page 295. And you'll see in fiscally short terms, it tells us that LME Clear reserves the right to amend any prices that it considers do not accurately reflect the current market price. So clearly the predicate for operating A610 is that there is a true, realistic, available market price. If that had been the case and some trade had been agreed at an outlying price, then the LME Clear could have used A610 to use a different reference price other than the outlying price for margining purposes. But in the situation that obtained on the 8th of March, where there wasn't a current market price because the market was completely disorderly to an extent that hadn't been experienced for 35 years, there was no current market price. So A610 simply wasn't an available tool. So in our submission, Milan-Friend's reliance on it is doubly irrelevant. One, because as a matter of substance, margining by reference to the Monday price wasn't a regulatorily acceptable thing to do. And secondly, as it happens, A610, in the circumstances that obtained, couldn't have been used. And essentially...
When you say it couldn't have been used because the market was disorderly, isn't the more direct way of saying it because the market was suspended?
Well, yes.
I know it's suspended because it was disorderly, but that's the immediate reason why there's no current market price, because no one's trading.
Yes, that is also true, yes. It may be stating the obvious, but margining decisions are taken by reference to orderly market conditions. If the market conditions have become disorderly, it is not LME Clear's function to sort of invent a market price, because the market price is meant to be the market price, not an invented price conceived by the regulator, by the CCP, and then imposed on the market. So in our submission, the arguments that Elliott ran in court below on this are, as I say, no better and indeed worse in this court, and there should be no difficulty in dismissing that line of argument. The next aspect of the decision-making that featured in my learned friend's argument was the risk of default under option 1B. Just to be clear about this, and my learned friend, in fairness, did say this, but just so that it's in the forefront of your mind, the risk of default on under option 1B was not something that featured during Mr. Chamberlain's formation of the cancellation decision. The second default risk spreadsheet was circulated right towards the end of the 9 o'clock call. Mr. Chamberlain saw it and looked at it afterwards, and in paragraph 232 of his first witness statement, he explains that it, I can't remember the exact word, confirmed or supported the decision he had taken, but it didn't in fact form part of his decision. So that's just a point of detail. The point of substance is clearly that the question of default risk under option 1B is another LME Clear issue. My learned friend in her oral...
Sorry to interrupt, but if you're right, if you are, on your previous submission, that the margining decision was lawful and rational, then this submission becomes irrelevant, doesn't it?
Yes, it does. I'm just ticking it off for the sake of completeness.
Yeah, no, I just wanted to see how it fits into the analysis.
If I'm right, it doesn't.
Once a lawful decision is taken that if the trades stand, then margin will be called by reference to those trades, then you say we're into the death spiral.
Yeah, exactly. But just for what worth and for completeness, we would not wish this course to leave thinking that there was any substance, even in this technically irrelevant line of argument. But the way my learned friend tried presenting it, and I have to admit I don't remember it being put this way in the court below, but I will be corrected if it was. The way my learned friend tried presenting it is that somehow Mr. Farnham's evidence that he considered that there would be a risk of default under option 1B somehow wasn't properly evidenced. And she pointed out that Mr. Farnham refers to some witness evidence of Mr. Jones, and that the relevant paragraphs in Mr. Jones refer to margining in relation to option 1A. With the greatest respect, Mr. Farnham's evidence is entirely clear and cogent in saying that he did take the view that option 1B involved a risk of default. He says that in paragraph 140 of his first witness statement, and in paragraph 18 of his second witness statement, in fact, 18 to 21 of his second witness statement.
Sorry, are we at cross purposes here? Sorry. I didn't understand her to be saying that there was no evidence that he took the view that there was a risk of default, but that there was no evidence, in the sense of no objective evidence, on the basis of which he could properly have formed such a view.
Well, in that, yes, I think that was certainly part of, if maybe the only point my learned friend was seeking to make. Two answers. The first is that his witness statement is a statement made on the basis, and he explains the risk assessment framework, which LME Clear relies upon. I lost my place temporarily. So the Mr. Farnham's evidence and his assessment of the risk of default under option 1B was based on LME Clear's institutional knowledge, which is backed by informed credit assessment over many years from the market risk team, and that's Farnham 1, paragraphs 14 to 21, paragraph 119, and paragraph 140. As it happens, we weren't particularly expecting that line of argument. I think Jane Street tried running it in the court below, and we had prepared some far more detailed evidential responses, because there was evidence in front of the court to support that in relation to a whole succession of the individual members from whom margin would have been called on the basis of option 1B. I think the paragraph numbers I've given you, possibly also with Farnham 2, paragraphs 19 to 21, contain the relevant evidence. But the fact is that there was evidence in front of the court that LME Clear applied its mind to the question by reference to the credit risk assessments that it had in relation to each of the members from whom margin would have been called that morning. And this was in the court below a judicial review as to whether or not LME Clear took a rational view. It wasn't a fact-finding exercise as to whether LME Clear was right, as to whether there was going to be default by 1 or 5 or any other number of members under 1B. The only question in front of the divisional court was whether LME Clear took a reasonable view on that, and given the structural evidence that Mr. Farnham gave as to the nature of the risk assessment process, and the positive assertion he made that he did consider in relation to those from whom margin would be sought under 1B, that he did apply his mind to and reached the view that there was likely to be defaults. In our submission, it can't be said that the divisional court reached a view that was wrong in the relevant appellate sense. This is not an appeal on the facts as to whether there would or wouldn't have been a default. I'm pointed at 2. Farnham 2, paragraph 21, I'm told is the best hook on which to hang that submission. And the final point just on this, Melania Friend, both I think orally and in her skeleton, blithely referred to only another 570 million being required by way of margin under option 2, under option 1B. I don't know whether 570 million is or isn't a large sum for Elliott, but the fact is that the market, the members of the LME are not all of the same size or with the same resources. Mr. Farnham took the view that he did based on the second default risk spreadsheet, on the basis, as I say, of the risk assessment views and data that had been accumulated, and of course the 570 million that would be required by way of margin under option 1B has to be judged in light of the fact that in the previous 2 trading days, already 11 billion had been sucked out of the market by way of the previous margin calls. So it's not sort of 570 million in isolation. It's on top of all the margin calls that had been made in the previous couple of days. So in our submission, the divisional court in paragraphs, just so that you have the note, paragraphs 205 and 206, the divisional court was entirely right in accepting Mr. Farnham's assessment of the risk of default under 1B, and there's no basis upon which Elliott can ask this court to take a different view. And yet again, all of that was argued and decided without reference to any supposed relevance of the contractual context. There is then the risk of under-collateralisation under option 1B, and in the interest of time, I wasn't going to add really to what we say in our skeleton. Essentially, it's the same point over again. The argument was had in the court below, the evidence says what it says, the LME Clear decision is what it is, and yet again, Elliott's position in this appeal is significantly worse than it was in the court below, because in the court below we had Mr. Dodsworth explaining his views on under-collateralisation. We submitted, and the court accepted, from a position of relative ignorance, he not having worked for LME Clear and not having experience of assessing collateral. So the position in this court is that there is no counter evidence against LME Clear's view that there was a risk of under-collateralisation. There is no counter evidence to it, but what there is a divisional court judgment, which in our submission is not one that this court should have any reason to try to consider overturning. So in relation to under-collateralisation, again, nothing to see here. We can move on. And again, we can move on without reference to any question of contractual context having featured in the divisional court's acceptance of the LME Clear decision in relation to the risk of under-collateralisation. So we move to the cancellation decision itself. Essentially, the argument in the court below from Elliott and Jane Street at that stage was that option 1B represented a less intrusive alternative, and that the LME acted irrationally or disproportionately in not adopting it. That's essentially paragraph 82 of the Statement of Facts and Grounds. The Divisional Court dismissed that challenge, and again, we will submit that it is not for this court to retake the same decision, and we would urge on the court the appellate approach that I offered in response to a question from my Lord Justice Singh at the beginning. I won't obviously leave it as spare as that, and just to walk through some of the contextual points first. One has, and this is the reason, in a sense, why I've tried to take the decision-making in chronological sequence. If one works through the framework within which the cancellation decision was taken, one starts with the fact, as we would submit it now, is that the LME had taken an entirely correct decision to treat the market as disorderly to an unprecedented scale. Secondly, that LME Clear had decided that calling margin by reference to the Tuesday prices would lead to the death spiral, and again, that's a given. Third point, LME Clear had decided, rightly, that if the Tuesday trades were allowed to stand, margin could not properly be called by reference to the Monday closing prices. Again, that just has to be accepted as a given. So the consequence of that, as the Divisional Court said in paragraph 106, paragraph 106, the consequence of that is essentially that the rejection of option 1B by the LME was an almost inevitable consequence of the margin decision. It couldn't leave the Tuesday trades standing, because doing so would require LME Clear to margin the market by reference to those prices, which would lead to the death spiral, which leaves, as Mr. Chamberlain says in his statement, the option of cancelling the trades as the only viable way forward. He describes the reasoning that leads to that, essentially on the basis that allowing the Tuesday trades to stand would, in his language, have been inconsistent with the conclusion that the market was disorderly to the extent that it was, and option 1B, as he understood, would have left LME Clear at a risk of being significantly under-collateralized, which again is essentially a decision, an assessment he inherits from LME Clear itself. So on the logical inconsistency argument, which my learned friend seeks to attack, there has been a repeated theme, consistent theme, repeated argument from Elliott, attacking a position we have never taken. Elliott has consistently tried to portray the decision taken by the LME as if the decision was that because the market was suspended, therefore the trades have to be cancelled. That is not what Mr. Chamberlain decided. He fully recognises that you can suspend a market without cancelling trades. What he says in his evidence, and it may be that paragraph 214 of his first statement is one of the clearest articulations of this. What he says is that it was because the market was suspended in the circumstances that obtained on the 8th of March, being as abnormal as they were, and the degree of disorder led to his conclusion that the basis upon which the suspension had been effected would be inconsistent with allowing the Tuesday trades to stand. So it's not the fact of the suspension that demands cancellation. It's the basis of the suspension in the circumstances that obtained on the 8th of March. Because essentially the disorder was of such an extreme degree, meaning that the prices were not representative of a true market. To have reached the suspension decision on that basis and then to leave the Tuesday trades in place would have been inconsistent. Because if those trades are not representative of a true market, then the logical thing to do is to cancel them. So that essentially is, it's Chamberlain, as I say, Chamberlain 1, paragraphs 214 through probably to 217, that best articulate that line of reasoning. The second, as I say, Mr. Chamberlain articulates in his evidence the two reasons. One is the logical inconsistency, and the other is the risk of under-collateralization under option 1B. Essentially, we don't have anything to add to that. I've already addressed the risk of under-collateralization under 1B, purely out of completeness. We would simply add, you may have seen reference in our skeleton, we say you don't need to get here, but just so that I haven't not mentioned it, we do say in our skeleton paragraph 91 that even if you reach the conclusion, contrary to our submission, that the margin decision was wrong, was unlawful, that wouldn't lead to the conclusion that the cancellation decision was wrong. We cite the authority of Shoesmith, which proceeds on the basis that if you're challenging decision A, and decision A is predicated on somebody else's decision B, the finding that decision B is unlawful does not necessarily lead to the conclusion that decision A is unlawful unless there is some other reason for doing so. I don't want to get into too much detail on that because in our submission you don't need to get there, but the argument is presented, as I say, in our skeleton at paragraph 91. The only other point we would wish to touch on in relation to this is a fallback argument, which I don't think my learned friend developed on her feet, but it's in paragraph 60 of her skeleton, where she says that the risk of under-collateralization was unquantifiable, and for that reason it did not form a sound basis for taking such an extreme step as cancelling the two-state trades. Our response to that it comes in several parts. The first is that it's wrong to view the lawfulness, the rationality of the cancellation decision by reference to the risk of under-collateralization in isolation. The decision on cancellation has to be understood in the context of everything that we've looked at before, most notably LME Clear's decision that allowing the Tuesday trades to stand, but marginally by reference to the Monday closing prices, was simply irresponsible. So one can't assess the reasonableness of the cancellation decision solely by reference to the sort of probative value, so to speak, of the risk of under-collateralization under option 1B. But the second part of the answer is that this line of argument from my learned friend is, with the greatest respect, exactly the kind of territory where the administrative court should not go, because it is preeminently a point of how much weight an appointed decision maker should attribute to a particular factor. If the risk of under-collateralization under option 1B is not an irrelevant factor, the weight that it should carry is a matter for the decision maker, and it's not for the court to second guess that evaluation. It's not for the administrative court. The administrative court, having taken the decision that it did, with respect, it's not for this court to have another go at an exercise that the administrative court rightly didn't undertake itself. So that is a response to the main line of attack on the dismissal of option 1B. The other argument under this head, which Elliott are running with, is to say that the LME should have disregarded any systemic risks to the market. And that is a point they make in their skeleton argument at paragraph 61. They say the risk of systemic damage is for LME Clear, and LME itself was required to disregard it. It is, with respect, difficult to be polite about that argument, bearing in mind the fact that the LME is required by regulation to run an orderly market. If a decision that it is contemplating would cause systemic risk of multiple defaults, which would damage the market and damage access to the market, it is, with the greatest respect, impossible to see how that is a factor which the LME, as a matter of law, is required not to take into account, which has to be my learned friend's argument. In our submission, there is absolutely no substance to this point at all. As I say, we saw the LME's regulatory obligations right at the very beginning. We've seen the evidence of the risk of multiple defaults in relation both to options 1A and 1B. And I don't think I need to labour the point in relation to those matters. So the only other thing, just to point out the obvious, I think this is picked up in the divisional court judgment, although I have to admit I don't have a paragraph reference for this at the moment, but the other point that is made in our evidence in Jones 1, paragraph 48A, is that when a member goes into default, he doesn't just go into default in relation to nickel. He goes into default in relation to the LME, so across all metals. So a default, and a fortiori multiple defaults triggered by events on the nickel market would inevitably have ripple effects in relation to the other metals markets, which were wholly unaffected otherwise by the spike in the nickel price on the 8th of March. And just so that you have the evidential basis for this point, the decision was taken, the cancellation decision was taken on the basis that the events of the 8th of March posed a systemic risk not just to the nickel market, but a contagion risk to the rest of the LME's metal markets generally. That is in Chamberlain 1, paras 205 to 206, Farnham 1, paragraphs 19, 115, 128, and Jones 1, paragraphs 40 and 41. Jones 1 you haven't had to look at very often, so I'll just give you the reference. Jones 1 is in the supplementary reference bundle 1, tab 8, page 133. So wrapping up on irrationality, we submit that there is nothing in Elliott's appeal based on the allegation either that the decision makers took irrelevant considerations into account or disregarded relevant considerations, or in their argument that LME's margin decision, LME Clear's margin decision, or the LME's cancellation decision, fell outside the range of reasonable decisions that were open to them as decision makers. And again, just to emphasize the point, none of the bases upon which Elliott even challenges the divisional court's ruling on these points turns on the divisional court having given LME Clear or the LME an unduly wide margin of discretion by reference to any contractual context. The whole thrust of my learned friend's arguments on irrationality are directed towards the inherent logic of the decisions under challenge. It's nothing to do with margin of appreciation. It's the inherent logic of the decisions that is sought to be challenged. And so we do urge on the court that although, and it may have been because the question of contractual context has some life in the Human Rights Act area, that it was at the forefront of the divisional court's mind when it was considering permission to appeal and why it mentioned it. But we hope we have satisfied you that the contractual context, although, as I say, there are the words on the page in the divisional court's judgment, that it is a contextual matter it takes into account, in relation to the issues that have been raised on appeal, it is, in fact, an irrelevance. Improper purpose, I can deal with pretty quickly. Improper purpose is the argument by Elliott that either the respondents favoured one cohort in the market, or that they wrongly took into account avoiding systemic risk, or that they wrongly took into account some desire to avoid making a margin call, or that they wrongly took into account protecting the LME's or LME Clear's own financial interests. Their arguments on improper purpose have been a little bit fluctuating, but I think that captures the various different ways the argument has been put over time. Simply in terms of the legal context, I don't think there's anything between the parties, and I don't think there's any challenge to the approach that the divisional court took, namely that the exercise of a power for a purpose other than that for which it was conferred would be ultra vires on Padfield grounds. So we then just look as to whether the Court of Appeal has any basis for reopening and reversing any decisions in the court below. The first issue, we can take together the allegation that the improper purpose was favouring one cohort in the market and or avoiding making margin calls that would be uncomfortable for them. So far as that is concerned, we submit that this is not a line of argument that is open to Elliott in this court. The divisional court made a finding of fact, accepting the LME's evidence, that the concern and the purpose was to avoid multiple defaults and systemic risk, not that it was seeking to favour one cohort or to avoid margin calls for its own sake. And that's the divisional court judgment, paragraphs 182 to 183. Elliott should simply not be allowed to try going behind clear findings of fact which were based on evidence presented by the LME and LME Clear. Elliott's argument in our submission simply conflates, for forensic purposes, motive with outcome. Yes, as it happens, cancelling the Tuesday trades had the outcome that certain market participants did not make losses they might otherwise have made. But that wasn't the LME's purpose. And the LME said so in its evidence very clearly in Chamberlain 1, paragraphs 9, 84, 227, 257, and 294 to 296. And again, on behalf of LME Clear, Farnham 1, para 99. Elliott had no evidence to challenge that, and they chose not to cross-examine any of our witnesses. In those circumstances, it is simply not open to them in this court to ask the Court of Appeal to revisit a finding of fact as to LME and LME Clear's purpose in taking the decisions that they did. The second aspect of the improper purpose argument from Elliott, they say that it was an improper purpose on the part of LME to avoid systemic risks. We've already dealt with that under the heading of irrationality, and there is nothing to add to that. And the third aspect of the argument that LME or LME Clear were pursuing an improper purpose is the allegation, which I thought had been abandoned in the court below, the allegation that they were trying to protect their own financial interests. There was originally in the Statement of Facts and Grounds an allegation in terms of bias. That was abandoned in the court below, and the reference for that is footnote 43 in Elliott's skeleton in the court below, which is Core Bundle 2, tab 2, page 460. Having abandoned the argument on bias, we do not understand how it can be open to Elliott now to be pursuing on appeal an argument that the LME or LME Clear was motivated by self-interest in protecting its own financial position.
My memory may be failing me. I don't remember that featuring in the oral submissions.
I think you may be right. It's in paragraph 63 of my learned friend's skeleton,
okay.
So I didn't want to leave it unanswered.
No, I see that.
And all we would say is that even if the allegation were open to Elliott in this court as a matter of sort of process, it would fail again for essentially the same reason as in relation to the favouring one cohort line of argument. We answered it in evidence, Chamberlain 1, para 9, Farnham 1, paras 67 and 148 to 149. No cross-examination, no proper basis for the claimants to ask even the court below to go behind those statements, let alone this court. So, conclusion on improper purpose, there is absolutely nothing to trouble this court, and that line of argument should be dismissed. So we can turn to procedural fairness. And the line of argument here is that Elliott was deprived of the opportunity of making representations, and that makes the cancellation decision unlawful. The legal principles in relation to this, the legal principles in relation to fair process were correctly summarised in the Divisional Court's judgment at paragraphs 152 to 156. And I don't think there's really any dispute about the applicable law. We would simply offer a few points of emphasis, so to speak, none of which I suspect are either controversial or particularly surprising. The first is that the demands of fairness are always context-specific. We have a long chunk from Doody in the court below, just to remind us of that. The second is that the question in any given case whether it is practicable to seek representations and whether it is compatible with a decision-maker's regulatory obligations is a matter that is peculiarly within the expertise of the decision-maker itself. And we cited in the court below, and it may be just worth looking very briefly at one case, because we haven't done very much case law, and you did encourage us to refer to as many as we could.
Yes, we're very disappointed.
Loutro ex parte Ross is in the Supplementary Authority Bundle 1, tab 9. If you have that open, so this is a case in which Loutro, one of the then self-regulating organisations, had banned an insurance company from accepting further insurance business from
Sorry,
members.
Mr. Crowe, I've got the wrong reference.
Oh.
Can you give it to me again?
I have it in the Supplementary Authorities Bundle 1 at tab 9.
Yeah, sorry, I was looking at the wrong file. Yes.
Okay, I'm correct. So Loutro had banned an insurance company from accepting further insurance business from members of the public through its authorised representative, which is an entity called WPLC, and the reason was concerns over the association of WPLC with someone whom Loutro considered to be undesirable. An intervention was effected without giving notice or any opportunity for representations. And could I invite your attention to page 341 with the bundle.
So this is in the divisional report.
Yes, it is indeed. And the relevant passage is sidelined. Could I perhaps just invite you to read that, but also over to B on page 342?
Yes.
I'm grateful. So that simply serves to illustrate the way in which regulatory decisions may need to be taken in circumstances where the regulator has to take a view on urgency, and the regulator will also need to take a view on the practicability and desirability of allowing representations before a decision is taken. Next point, just briefly still...
I'm sorry, Mr. Crowe, I'm not sure, it's my fault, I'm not sure what the submission is that you're making. Because as I understand it, from page 342, letter B, Lord Justice Mann ultimately reaches a legal conclusion about what the law requires. Have I got the reasoning right? He says, in my judgment.
I'm sorry, you're at which page?
Page 342.
342 at...
Letter B. So it appears to me the omission from the voucher rules reflects an omission from the Act, and in my judgment, the omission was made with a deliberation in each case, which makes an implication impossible. In other words, an implication that there's a right to make representations in advance. So there's a lot of reasoning which leads up to that conclusion.
Yes.
But ultimately, as it seems to me, the court reaches a conclusion of law.
In the circumstances of that case, in that particular regulatory context, that's what it led to. I just wanted to cite the earlier passage to illustrate the ways in which the context of regulatory decisions needs to be taken by reference to the regulator's appreciation of whether or not representations are required. Having had my attention drawn back to that passage that you've just identified, that too has resonance here, because as I will come on to submit, on one of the features of this case, and it's got nothing to do whether it's got a contractual basis, it's just that the rules in this case also provide no express regime for representations before a cancellation decision is taken. So we would submit that both in terms of taking a contextual approach to whether or not the law implies an obligation to allow or invite representations, one gets, in a sense, two things from this. One is the point you've identified, which is that you take a view as to what the actual, in a sense, I mean, I think the judge there was almost talking about implied terms within the regime.
Yeah, well, that's what natural justice is. Cooper and Wandsworth, Board of Works.
Yeah.
The common law will supply the omission of the legislature.
Yeah.
It's almost always an implied term into some statutory procedural framework.
Absolutely.
But usually you will imply it. Doody says that. Usually you will imply it. So there has to be a good reason not to imply it. But you say here there is a good reason.
We say that here there is good reason, and whether or not there is a good reason, one can derive from contextual considerations such as, is it a regulatory decision that has to be taken under time pressure, such that allowing representations would in fact not be viable. And of course that also then ties in with Lord Neuberger's comments in Bank Millat
Yes.
about impractical I can't remember.
All of that I understand, but I just wanted to be clear whether you're submitting that procedural fairness requirements are or are not a matter of law for the court to decide what the answer is, or whether it's any part of your submission that what procedural fairness requires is a matter for the decision maker, provided it's not an irrational view. Because if it's the latter submission, I'm not sure Latcher says that, but even if it did, that would be inconsistent with the Supreme Court decision in Osborne.
Yeah.
Which of course is much more recent and more authoritative.
Yeah, yeah. No, for sure. No, I mean, what procedural fairness requires is what the law demands.
Yes.
Yes. I entirely accept
very
that. But what the law demands
Exactly.
is context
I
specific.
completely understand.
Okay. I'm grateful. Just a couple of other short points on the legal position before we get on to the submissions. Milan Friend referred very briefly to the British Blinds case, and she appears to submit that fair process requires, as a matter of law, a positive invitation to make representations in every case. In our submission, that simply isn't what can be derived from that case, and it isn't the law. What procedural fairness requires is, as we've explored, context specific and isn't a single regime applicable to all situations. The final couple of points we would just make are these, that there was some discussion yesterday about the two types of situation identified by the court in Cabell between sort of public consultation on generally applicable legislation and decision-making that impacts on a person. And the language of allowing representations and conducting consultation has been coined to try and sort of capture the difference between those two. If it is useful to try applying that kind of prism to this situation, in our submission, we are much nearer the public consultation end of things for factual reasons, which it may be helpful if I defer for a moment, but I'll get to them because they impact on the viability of conducting any sort of mini referendum in this case. But just so that to park that as a sort of legal issue, if, as I say, it is helpful to try bracketing this within the sort of public consultation or targeted decision-making categories. Although you've only got Elliott in front of you, in fact, it is a far wider cohort of people who would have been affected. And I'll come to that in a moment. I just wanted, as I say, just to part the thought as to the legal issue that will come into play. The final question is that one of the factors, and we touched on this very briefly in our exchange, one of the considerations that if no one else, Lord Neuberger mentions in Bank Millat, is that if it is not viable, if it is impracticable to conduct consultation or to seek representations in any given situation, then the law is not going to demand the impossible. And this, in a sense, does again slightly circle back to the sort of point of principle my Lord Justice Singh just raised as to whether this is a question of law or of expert evaluation. On this point, in our submission, the law does have to take account of what the expert decision maker considers to be viable, because whether or not consultation or allowing or inviting representations was a viable, practicable option on the morning of the 8th of March is not something to which the court can reach a view uninformed by the evidence. And the evidence is the view of the expert decision maker. And so when it comes to that aspect of the application of the test of fair process, the court does, with respect, have to take into account the evidential position. So turning then with those legal submissions in mind, turning to the with the legal context in mind, turning to our submissions. So I just wanted again to start by looking briefly at the extent to which, if at all, the contractual context is live here. And there are just two paragraphs that I think my learned friend mentioned in the divisional court judgment I just wanted to remind you about. So it's paragraph 159 is the first. What the court says, and this is quite condensed, and in a sense it's best understood in light of what the submissions were in the court below, but the words on the page are, in Plantagenet Alliance, the divisional court expressed the relevant point in terms of a democratically elected body. Judicial deference to a decision by a rulemaker not to impose a duty of consultation must no doubt be at its highest where the rulemaker has been democratically elected. However, as noted in section G above, it seems to us significant that in this case the claimants consented to TR 22.1, and they must be taken to have appreciated that its terms do not require prior consultation. Now, our submission on that is that this is not an instance of the divisional court saying that the contractual context is relevant to the intensity of scrutiny or any other judgment by the court. What it's saying, and at the beginning of the paragraph, when it talks about Plantagenet Alliance expressing the relevant point that had been debated by reference to Plantagenet Alliance in the court below was whether a court should imply an obligation to consult in circumstances where a legislative regime did not. So the fact that Plantagenet Alliance involved a legislative regime didn't read across automatically to our case because this isn't a legislative regime. So the court in our submission is simply saying in this paragraph, okay, Plantagenet Alliance is talking about the court not imposing an obligation to consult if legislation doesn't expressly require it. We don't have an express legislative regime. What we have is a contractual situation in which Elliott consent to participate. And therefore, the fact that it has consented to participate in a regime that doesn't expressly require representations to be made before a decision on cancellation is made, in a sense, carries the same implication in terms of analysing whether the court should impose an obligation to allow representations, as in a situation where the regime is laid down by legislation. The actual point of substance, leaving aside structure as to whether the source of the regime is legislative or contractual, the point that the court is simply getting at is what is not in the contractual regime. It's not saying that its own conduct as a reviewing court conducting judicial review is influenced by the fact that it's a contractual regime. What it is simply saying is that it is presented with a regime which doesn't have an express right on the part of a person who may be affected to make representations before a cancellation is decided on.
Well, that's almost always the case. That's why we have the case law on natural justice. When you apply for British citizenship as naturalisation,
yes.
There's no express right to make representations before your application is refused.
Yes.
Court of Appeal held. There is an implied requirement to do so. It could be said that when you apply for naturalisation, you do so in the full knowledge that the statute doesn't require prior consultation. So
Yes.
what?
Well, Lord, I'll come to that in a moment. But all I'm trying to deal with at this point is what actually is the relevance of what is being said in paragraph 159. The so what, I agree, is a question that needs to be answered, whether it's a legislative or a contractual situation. All paragraph 159 is saying is it doesn't make any difference to what was said in relation to the Plantagenet Alliance case, that this happens to be a contractual case. All it's saying is they're both situations in which there is an absence of an express obligation to consult or an express obligation to require representations. So it's not suggesting that a different test should be applied. The so what question could be made in relation to both. I completely accept that. But all I wanted to try and make clear is that.
Okay, so that's that paragraph.
That, and then 165, I think, is the other one, yes. Mr. Chamberlain did, in fact, hear from some clearing members who were concerned about the consequences for them. We don't accept that this made the decision unfairly one-sided. Those parties, too, were not saying anything that was not already obvious.
Wrong paragraph.
Oh, I'm so sorry. I'm reading. Yeah, I've got the right paragraph. I was reading the wrong one. I do apologise. Accordingly, we reject the claimant's case in relation to procedural fairness and the failure to consult. Consultation was not expressly required under the LME rules or LME Clear rules. It was the LME and LME Clear to decide whether, at whom, and how to consult, and they're entitled to a wide margin of discretion. In these circumstances, especially the urgent context, there is no duty to consult the claimants. So that, in our submission, is a proposition based on the arguments. Sorry, not proposition. It's a conclusion. It is an acceptance of the argument that was advanced in the court below, which I will repeat to you briefly. That the view of the LME and LME Clear was that it would be impracticable to consult in the circumstances that obtained on the 8th of March. It isn't a sort of decision of principle that in all circumstances and in all cases, LME Clear and the LME can simply decide to affect people without consulting them. That's not what the court is saying. What it is saying is essentially, as I say, by way of acceptance of the submission made in the court below, which is that, for reasons I will very briefly outline, it would have been impracticable to conduct a mini referendum on the morning of the 8th of March. The only point, well, we have that open. Oh, yeah, sorry. And there's one other point while we're on the judgment, where while we got it open, I thought we might just turn to it now, which is actually paragraph 163. Because my learned friend made a point about this, and it may just be convenient to deal with it.
If she did, I didn't mark it. But
okay. So in paragraph 163, what the judgment says is, finally, Mr. Chamberlain stated in his evidence that his view was and is that any consultation would not have provided any useful information because the views expressed would simply have reflected the respective interests, already obvious that there would be winners and losers. So on the back of that, as we understand it, Milan and Friend's submission was that the divisional court applied the wrong test. She says the correct test for deciding whether or not there's a breach of the requirement for fair process is whether consultation could have produced a different answer, not whether it would have done. But that in our submission, when one looks at the way that the divisional court was deciding the point, isn't a good point. That they were not framing the question, would consultation have made a difference? They were simply actually saying consultation would not have provided any useful information. which excludes the possibility that it could have done. So there isn't, in fact, any wrong test being applied there. Moving on.
Sorry, are you moving on from 165?
I was going to move on from the Divisional Court judgment altogether.
Ah, well, 165, I think Ms. Cars-Frisk submits, does contain a misdirection of law, because she submits, as I understand her, that 165 is inconsistent with Osborne, because this appears to think that procedural fairness is a matter for the judgment of the decision maker, subject to a wide margin of discretion, whereas Osborne holds that it's a matter of law for the court. Yeah,
and our submission, as I say, that although I accept it's not as happily worded as it might be, that what 165 is in fact doing is not expressing a principle of law as to the generality of cases, that it is for a decision maker to decide who to consult with. What it is saying is that in the particular circumstances of this case, the court was required to accept the expert evaluation of the LME and LME Clear as to whether, in the circumstances that obtained that morning, it was feasible within the Bank-Millat exception, impracticable, to conduct any form of consultation exercise. And on that point, the LME and LME Clear are entitled to a wide discretion, because they are the ones who can best evaluate whether or not a consultation process is a viable one. And I was going to come to the substance of those at that point in just a moment. So just to finish before getting on to that, a couple of other contextual points. First of all, we've already ticked urgency, and the urgency of the circumstances on the 8th of March were particularly marked, accepted as such by the Divisional Court. No reason to revisit that. Second point is that the related questions of margining on the 8th of March and the status of the Tuesday trades would have impacted on an unknown class of persons. As I say, you only have Elliott in front of you, and you should not, simply because of the forensic lineup, be misled into thinking that this is a sort of a bilateral dispute. The decision that was taken in relation both to the status of the Tuesday trades and the related question of margining impacted everybody who had an open position in nickel. It's not just the people who traded that day, it's not just the people who were long or short, it's everybody who had an open position in nickel. And that is an indeterminate, well, it's an unknown class so far as the LME is concerned, because...
Well, the class is known, you just don't know all the people who are in it.
Sorry, all right, yes, you can define the class without knowing who's in it. No, absolutely fair point. Because obviously the LME Clear is clearing only with clearing members. Clearing members have clients. Elliott is not a clearing member. So the LME and LME Clear do not know the entire makeup of the class of those who would be affected by their decisions. But
the short answer to that, which, as Charles Frisk suggested, was you simply put out a general notice to all the people who are on the mailing list for receipt of your notice and say, we're going to have a call at sometime between 9 o'clock and 12 o'clock.
I was going to come to this, but
I see. We'll do it
later. No, we'll do it now. It's either the first or the last point, or the middle point. So, supplementary core bundle, tab 11. This is the suspension decision. And under the heading Actions, it tells us what the LME is doing. And then under Next Steps, it says at paragraph 8 that LME will actively plan for reopening and will announce the mechanics as soon as possible. And then paragraph 9, the exchange will further consider whether trades booked prior to 8:15 today should be subject to reversal or adjustment, and will again update the market as soon as possible. 10 questions. Members who have questions regarding this process should contact their relationship manager. So the difference between what the learned friend is suggesting should have happened and what the LME actually did is pretty thin. Because the LME notified the market what it was contemplating doing. It suggested they got in touch if they had questions. Some people, we know, did. For whatever reason, Elliott didn't. Although Mr. Holbrook says he knew about this decision as soon as it was published. So there is an argument of law in front of you that the LME was positively required to do something more than tell the market what it was thinking about and let them get in touch. So there has to be a legal argument that it was legally obliged to conduct an organised joint Zoom meeting or something. Well, what on earth would that look like? And who would be awake? There would be traders across the world who might well be in bed. There would be members. There are, I think, 46 members of the LME, clearing members of the LME. So we got 46 members. They have, I don't know how many clients. The members themselves will have proprietary positions. They may have proprietary positions which are commercially opposite to their own clients' positions. So what on earth is a Zoom call going to look like other than a shouting match? Or total silence, because nobody dares to say anything about what their market position is. And it's precisely because of that kind of conundrum that the LME and LME Clear take the view that it's just not realistic to conduct a Zoom call. Of course, Mr. Chamberlain answers the phone if somebody rings up. In the course of oral submissions, the learned friend said that the LME conducted a kind of consultation. It didn't. What happened was that Mr. Chamberlain answered the phone and he returned a call if he had missed somebody's call. But that's just sensible client relations. He's not conducting some sort of census as to what the market view is. And he says in his evidence, sorry.
I thought your submission was going to be what they did gave the substance of consultation.
Yes.
But actually, well, I thought more as you developed the submission, it seemed to be consultation is actually impracticable.
Well, what they gave was the opportunity to make representations, which is what Elliott says it's been deprived of. It has not been deprived of anything. What they didn't do, sorry, what I was just developing was because we did effectively allow representations, but it was an invitation that wasn't taken up. What I then said, I saw it probably took it in too condensed a way. What I then said is that given that we did offer that, in order to have any legal argument, what my learned friend has to submit, and I think she was submitting, is that the LME was under a legal obligation to go even further and actually organise a conference call at which people are then invited, which yes, I assume is why she went to British
clear that was her case, yes.
And we're saying that that is wholly unrealistic, and that is the process upon which the divisional court was commenting in the paragraph we've looked at. I mean, the divisional court knew perfectly well that the suspension notice invited representations.
Did they make reference to that?
I think
in that section of the judgment, which contains their analysis and application, it's 161 to 166. But if I may say so, Mr. Crowe, you've made your submission very clearly, and I understand it. It's probably my fault. I hadn't understood that to be the reasoning of the divisional court.
right.
Because what you're really saying, but please correct me if I've misunderstood, you're not really saying this is a context in which it was impossible to give any procedural fairness at all. What you're saying is that, as duty tells us, what procedural fairness requires is always dependent on the context. Here the context included urgency and all the other things you've told us about. Actually, there was some opportunity to make representations which was afforded, and you say that's good enough in the context. Now, and you may be right, but I hadn't understood that was the reasoning of the divisional court.
Right.
But maybe I'm being unfair to them.
I wouldn't wish to comment on that. I may not have articulated our reasoning to the divisional court adequately. Just if you want an evidential note as to why a sort of group conference call would have been impractical, it's expressly addressed by Mr. Chamberlain in paragraph 230 of Chamberlain 1.
Can I just ask a practical question? Do interested parties other than members have a relationship manager?
Ooh. I will find out, and we those in court don't believe so. I will come back to you if that's incorrect.
I mean, I'd have thought that it's unlikely given the way trading has been explained to us.
Yeah.
I think you made the point, but maybe I misheard, that on a public Zoom call, it would be unlikely that individual traders would either reveal the state of their book, i.e. whether they were long or short and the rest of it, or go into any detail about the likelihood of them defaulting if certain events happen. I can see the logic of that submission if you didn't make it, but is there any evidence that that was part of Mr. Chamberlain's thinking at the time?
I think I'll have to check. What I do remember very clearly is that one of the arguments that's been dropped by Elliott was a complaint that the BRC, the Board Risk Committee, wasn't consulted. The Board Risk Committee has a membership which includes members as well as LME, I think, Clear officers. And the evidence about that was that it would have been impracticable. I mean, as it happens, it was procedurally unnecessary to consult the BRC, but the evidence certainly in relation to that, and we can find the references, was that it would have been impracticable to consult that precisely for this kind of reason. I don't know whether in terms that evidence was then sort of re-articulated in relation to not holding a wider conference call, but the logic applies.
I think the impracticability which Mr. Chamberlain refers to in his paragraph 230 is first, that they don't know who all the relevant people are, and second, that unlikely it could be done in a reasonable period of time, i.e. the urgency.
When it says at the top, all members and other interested parties, members, clearly they will have a address that's set up for. Interested parties may be addressed to them, but if interested parties is meant to include clients, LME presumably wouldn't have direct contact with clients. They would be dependent, though the text doesn't say so, on members forwarding this to their clients, which is presumably how Mr. Holbrook got to know of it.
That is certainly my understanding, and I believe that's right, yes.
As soon as it was published.
Yes. I mean, as it happens, Mr. Holbrook says as soon as it was published. So
Yes, well, I can easily understand. For all I know, it went on the website as well, and it was a secret document. But in terms of who there were active steps to send it to, it's unlikely to have been anyone other than members.
Yeah.
They would know the identities of clients whose trades had been executed, such as Jane Street, I suppose, but they wouldn't know whether they had captured everybody.
That's just while you're thinking about that, I expressed myself badly. It wasn't so much that their records wouldn't show who clients were, but they wouldn't have, as I understand it, direct dealings and contact details for clients, or that the trade wouldn't generate that.
Yeah, no, exactly. That's certainly the point I was answering, and I do believe that is right. Could they work out from their systems who underlying clients were?
No, well, maybe I see. Maybe not, because the contract is still with the clearing member.
Yeah. So on the hoof, the best answer I can give is that when trades are booked, they will be booked with a reference number. LME Clear won't necessarily know to whom that reference number applies. I don't know if by some process they could work it out.
Well, it's
but
small.
in any event, the fact is they don't know sort of up front, so to speak.
Mr. Crowe, if I may say so, this is helpful, and I think it may have a bearing on the legal submission you were making about 10 minutes ago, that insofar as what I said in Kevel is helpful to draw the distinction between sort of consulting generally and giving a prior notice to specific people who are affected. I think you would say this is a case unlike Fired, for example, because when Fired applies to the Home Office for naturalisation, there's a direct relationship between applicant and decision maker. So everyone knows who it is that you're talking about. Whereas here, I think what you're saying, but correct me if I'm wrong, is that this is a bit like the general consultation problem. If the express rules have not defined exactly whom you have to consult and when and how much information you have to give them and all, you know, the kind of thing that is often in express regulations.
Yeah.
And I think that your submission is that it's closer to that kind of scenario. And in that context, they did issue the notice at page 291, and that was good enough.
Yeah. Yes. That is the submission, and we would respectfully invite you to. Sorry, can I just check one point? Yeah. Yes, I've just been given confirmation that the suspension notice was published on the LME website.
Yeah.
The other point.
Just spelling out the implications of that. I'm sure in this busy time, some people would have thought to go to the LME website, but that is very different from getting an email in the inbox of the person responsible for LME trading, nickel trading.
No, accept. One other point, and I want to deal with this relatively lightly if I can, because I'd quite like to try and finish Viaries today as well, and then just leave human rights for tomorrow. One other point just on consultation is that Elliott's explanation as to what they have been deprived of the opportunity of saying has fluctuated over time, and our submission wouldn't have made the blindest bit of difference. What they have said, and this is paragraph, I don't ask you to go to it, but paragraph 41 of their skeleton. They say they were deprived of the opportunity of suggesting less intrusive measures. Well, either the less intrusive measure of option 1B was rationally dismissed, in which case having Elliott bending their ear wouldn't have made any difference. Or, dismissing option 1B was irrational and unlawful, in which case this point doesn't add anything.
That can't be quite right. It could be that 1B was a 50-50 call and it was rationally refused, but Elliott had a good chance of getting you to jump the other way. I think you're putting it a little bit too starkly.
Well, we would submit that the grounds upon which 1B were discounted, the reason that option 1B was discounted, it certainly isn't a sort of 49-51 decision. As the divisional court effectively said in paragraph 106, the LME was substantially driven to the conclusion.
Oh, well, that's fine, but that you were putting it rather differently from that. You were saying that as long as it was a rational decision, it didn't make any difference.
Yeah. No, sorry. Okay. Sorry. No, fair. Yeah. The other point made in Elliott Skeleton, they say that they could have drawn attention to rational explanations for the price movements. And this is it was a market squeeze, and a market squeeze is perfectly acceptable because it's all just, how life works. But again, that doesn't advance their argument, because that is precisely the line of thinking that Mr. Chamberlain took into account and discounted. So they haven't been deprived of an opportunity of pointing something out he didn't already know. It also implies that Elliott knew something about the causes of the price volatility. And it's interesting, sorry, it's getting a little bit granular, but paragraph 41 of Malone and Skeleton floats this as one of the factors that Elliott was deprived of the opportunity of drawing to the attention of the LME, namely rational market explanations. The evidence of Elliott, Mr. Holbrook, does not assert that he knew anything that he would have told LME or LME Clear. If you look at his evidence, he doesn't say he knew what was right. He could see press reporting and rumours, but he didn't have any evidence that he could put in front of the LME. And so, again, in our submission, that line of argument doesn't assist Malone. And the final point made in their Skeleton, paragraph 41, they say that they were deprived of the opportunity of dissuading the LME from seeking to protect one cohort of market participants, which is not what the LME did. So in our submission, for a large number of reasons, it is the case that the steps that were taken were enough, and further steps could not reasonably have been taken as suggested. So we submit the appeal on procedural fairness should be dismissed.
There is another point which I think Mr. Galsworth made in the context of proportionality under A1P1, but I suppose it also comes in potentially here and at other stages of the analysis, and that is that they could have suggested what I suppose would be option 4, which is cancel the trades but pay us some compensation. Are you going to cover that?
Well, I have to admit, we were a little bit surprised.
I don't know whether that was a point that has been ever raised before.
Well, it was, and it wasn't pursued in the notice of appeal or the ground or the Skeleton, so I was a little bit surprised to hear that. And the answer is that unlike the Financial Services Compensation Commission, or whatever it's called, scheme, LME and LME Clear do not, impose a levy on the industry to set up a fund to provide compensation. So the scheme is simply not there in order to, there isn't the structure for achieving that outcome. Malone and Friend mentioned in passing Article 17, Trading Regulation 17, which refers to compensation. But, and I'll dig out the references to our Skeleton in the court below that dealt with this. But the answer is that is not talking about compensation from the LME or LME Clear to a market participant. It's talking about compensation in our submission as between parties to a trade which get cancelled. Because the peculiarity of the outcome that Elliott would be tilting at in seeking compensation is that the trade remains cancelled such that the counterparty is relieved from its liability, but somehow the regulator ends up providing the profit or part of the profit for the other party to the contract. In our submission, that is simply not a coherent outcome. The regulator isn't there to compensate or to sort of to produce a distorted commercial outcome in which one commercial counterparty is relieved of liability, but the other one still either scoops the pool or gets a substantial whack. So, but as I say, that was slightly off the cuff because we weren't expecting to have to deal with that, but we did deal with it in more detail in the skeleton below. And in our submission, it's...
Perhaps you'll just remind us of the references.
Yeah, I'll get those for you tomorrow. Yeah, I think there was, my friend may have flirted with the idea that somehow the LME Clear could use collateral to pay compensation, which would be heresy, because the whole point of LME Clear is that it is, under the obligations we've seen, is that it has to maintain adequate adequate collateral. If it's pouring out its collateral to compensate individual market participants, it's plundered the piggy bank that's meant to be there to deal with defaults.
But not even their money, is it?
No, absolutely not. So just very quickly, I was just going to say a couple of words, although I partly anticipated this. I've got a little section headed proper defendant to the JR claim, but I think I probably anticipated this when I made the submission earlier that the Divisional Court clearly decided in paragraphs 81 and 106 that the cancellation decision was a decision of LME, and the margining decision was a decision of LME Clear. If the cancellation decision is unlawful on its own terms, then a ruling can be made against LME. But my learned friend's attempt somehow just to sort of fudge the two together in our submission is, as I say, in terms of principle analysis, wrong, but forensically not open to her because she hasn't appealed against the relevant rulings in the court below. Which leaves me with Varies, and I know
yes, well, I was just
about 10 minutes.
I've got 10 minutes. If you want to make a start,
can I crack on?
Yes.
Yeah. So Varies. Essentially, our position is very, very simple. We say MiFID Article 48.5 imposes a positive requirement that the LME shall be able to cancel trades in exceptional cases. That requirement is carried over into the domestic regime by the RRR, Schedule 1, paragraph 3b. Incidentally, we have checked. Eccentric though it may appear, the thing that's in the bundle is the domestic legislation. If you go through it, you'll see.
I didn't notice that, but I thought, oh well, you're going to explain, as you now are.
I don't know whether it's actually a schedule to some, one-page statutory instrument, but that is actually downloaded from the gov.uk legislation website.
Yes, I've not understood. I just haven't happened to have any cases about it. Just how these sort of retained.
I don't think.
My lord, forgive me. We had an example with the UK GDPR.
Oh, it doesn't look like this, does it?
I thought it did.
Well,
But it doesn't.
it's not worth spending time on, save only for this, that if someone can just tell us overnight exactly how it's done, we can just put a sentence in the judgment.
Yeah, absolutely.
I mean, if there is a missing front page, one-page heading with the regulation, that might be worth having.
Absolutely. All right, we'll follow that up. But sorry, just to revert.
Yeah.
So our very simple submission is MiFID positively requires a power to cancel. We have the power to cancel under the RRR. that requirement is carried over to domestic law by the RRR. Trading Regulation 22.1 gives effect to that requirement by conferring on the LME a power to cancel trades in exceptional cases. The cancellation decision was therefore within the powers of the LME. Any other outcome requires my learned friend to persuade you that some subordinate regulation has detracted from the effect of the requirement of the primary legislation. The primary legislation requires this power to be there. Both of my learned friend's arguments as to the requirement for a policy and as to the effect of RTS 7, both of her lines of argument involve trying to persuade you that some subsidiary legislation giving effect to certain aspects or supportive of, or I can't remember the adjectives that are used, are somehow derogating from the effect of the primary legislation. And our submission, simply as a matter of structure, that's got to be wrong. So the first way in which Malone Friend seeks to persuade you that that's the right outcome is to say that TR 22.1 is constrained by RTS 7, and she says RTS 7 lays down an exhaustive account of the circumstances in which trades may be cancelled. So if we look at whether RTS 7 is actually doing that, so it's Core Authorities Bundle 1, tab 4, page 388. Well, actually, I don't know if you have enough desk space to have open side by side TR22.
Well, we could try. Remind me where TR22 is.
TR22 is going to be in the Supplemental Core Bundle tab 14 at page 312. And RTS 7, Article 18, which is the relevant one, is the, as I say, Core Authorities Bundle 1, tab 4, 388. And as I say, the argument is that Article 18 lays down, according to the learned friend, an exhaustive account of the circumstances in which the cancellation power can be exercised. And our answers are very shortly these. First, if one simply looks at TR 22.1, it is entirely unconstrained on its own face. So if you look at it in isolation, it is subject to no restraints, constraints, or prior conditions. The second point is that if one looks at RTS 7, Article 18, it does not purport to lay down an exhaustive definition of the circumstances in which a cancellation power can be exercised. And we say that because in Article 18.1, it says trading venues shall have at least the following arrangements in place to prevent disorderly trading and breaches of capacity limits. And 18.2, which is the provision Learned Friend relies on, is it opens with the words, for the purposes of paragraph 1, trading venues shall be able to, ABC, and then D, cancel or revoke transactions in case of malfunction, and so on. So the list of things that are in 18.2 are there for the purpose of identifying what a trading venue has to have at least. It is not at most. More generally, we say, thirdly, RTS 7 was introduced under MiFID II, as we see from its recitals, the very beginning. So if we go back to page 3, so Core Authorities Bundle 1 at page 3075, it's immediately under the date, 14th of July 2016, supplementing directive, the MiFID directive. So it is, if I can call it this, a lower order form of legislation, which is there to supplement, support, not undercut the requirements or constrain the requirements of MiFID. It is there to give them effect. MiFID positively requires the cancellation power to be there. This can't then cut down the circumstances in which such a power can be exercised. More specifically, RTS 7 was introduced...
If more specifically means taking more than a minute, I think you're going to fall short of your target of finishing. I have really got to go at 5:02.
My 1 minute is to just remind you of what was put to my learned friend orally in the arguendo, which is that recital 1 of RTS 7 says it is important to ensure that trading venues must be capable, that trading venues that enable algorithmic trading have sufficient systems and controls. Recital 3, impact of technological development and particular algorithmic trading is blah, blah, blah. And recital 5, I'm told, is helpful. And finally, page 378, the very heading of RTS 7, General Organisational Requirements for Trading Venues Enabling or Allowing Algorithmic Trading. Article 1, this regulation lays down detailed rules for the organisational requirements of the systems of the trading venues allowing or enabling algorithmic trading. It refers to LME Select. It does not refer to the LME as the provider of at least 2 other venues.
Thank you.
Maybe a minute and a half.
Well, I think if you have just got a little bit more of this and you've got your A1P1 and we're going to have no time difficulties tomorrow, even if we are a little bit generous about not holding Ms. Charles Frisk to what she has lost from her reply time, though I make no promises about that.
Good.
So 10:30 tomorrow.
Court rise in favour.